Meeting of the Wyomissing Zoning Hearing Board to order. The first order of business is to explain to you or remind you that everything we do in the meeting is being recorded for posterity, so speak wisely. No bad remarks. Okay. Now, we're here today to hear an application for variance for the terms of the Borough of Wyomissing ordinance by Mr. Keith Mooney on behalf of his client, Iris Club Apartments LLC, the owner of the property located at 1110 Fairview Avenue and identified as tax parcels which are listed. He is requesting a variance from section 422, uses permitted by right, to allow a 7th apartment unit to be occupied at the property, and a variance from section 609.2 off-street parking to allow 14 off-street parking spaces to be provided at the property, measuring 7 feet 7.2 inches by 18 instead of the required 9 feet by 18 feet. And a public hearing is going to be here today. So, before we begin, I would like to introduce the people at the table in case you don't know them. Michelle Bear, everybody does know. Nigel Batish is a member of the Zoning Hearing Board. In the box on the table is Bob Ullman, who's a member of the Zoning Hearing Board. Counsel is Dan Becker. Our residential zoning officer is Jeff Hogue. And I'm David Rothman, the chairman of the board. Mr. Becker is going to explain how we're going to proceed.
Thank you very much. So I will note for the record today we have a pretty full house here. We'll go through with each of you to kind of find out why you're here, whether you're just listening or whether you want to stand and participate in the hearing. I also will note that the applicant, Iris Club Apartments LLC, is represented by Mr. Keith Mooney, and I see that you have your client here, Mike Trevnick. So let me just explain the process for you. I know, Mr. Mooney, you've been through this before, and I think you know as well as you should. So the way it works, it's your burden of proof. So you have to be able to provide testimony in the form of exhibits and or your oral testimony to explain why the relief that you're requesting should be granted. After you provide your testimony by yourself and or your witnesses, the zoning hearing board members and I and anybody who has requested and has received standing will have the opportunity to also ask you questions. After all of your testimony has been presented in your rest, to the extent somebody has requested standing, they will have the opportunity to present their witnesses and exhibits. We'll have the same process for them, we'll be able to ask them questions as well. At the conclusion of all of the testimony, to the extent there's somebody here that would just like to make a statement for the board to consider, will have the opportunity to make a statement. After all the evidence has been submitted and the hearing is closed, the board will go into an executive session, at which time they will consider the application and decide whether relief should be granted or not. Typically, the board will render an oral decision tonight. They have, however, 45 days in which to render a decision. Does everybody understand the process for today's hearing?
Yes.
Any questions for tonight's hearing?
No.
I see no questions from anybody in the audience as well. So at this point, what we want to do is we want to swear a couple people in. Well, actually, before we start swearing people in, let me go and find out, is there somebody here that is looking to request standing, which means that you'd have the opportunity to file appeals and or get certain notices that as a result of hearing, or are you here just for the purpose of listening and potentially making a statement at the end for the board to consider? Is there anybody that would like to request it? All right, I see none. So we will come down to each of you at the end of the hearing to see who would like to make any statements they would like to make. Okay? So at this point in time, what I'd like to do is swear in a couple of people. I'd like to swear in Mike, you, and I'd like to have Michelle and Jeff Hogue sworn all at the same time.
Raise your right hand and state your full name.
Jeffrey Hope, Michael Sherman.
Michelle Bear. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
All right. At this point, Mr. Mooney, I'll turn the floor over to you, and you can start with the presentation of the case.
I'll call my first witness, and my only witness, Mike Shervanek. Mr. Shervanek, could you please state your full name and business address for the record?
Michael J. Shervanek, and the business address is 575 Spring Street, Wyomissing, PA, unit 1119, 19610.
And are you associated with the Iris Club Apartments LLC?
Yes,
Can you explain your association with the Iris Club Apartments LLC?
I'm the primary owner.
All right. When you say you're the primary owner, you're the managing member?
Yes,
Showing you a deed that's been marked as Exhibit A1, do you recognize that?
yes,
Is that the deed for 1110 Fairview Avenue that shows that the Iris Club Apartments is indeed the owner of the property?
yes it is.
I'd ask the board to take judicial notice of the certified copy of the deed that's in your packet.
So,
Huh?
yes, sir.
Thank you.
So, thank you.
As the managing member of the Iris Club Apartments LLC, are you authorized to seek the variances that you are requesting today?
I am.
Have you sought a variance in connection with the property at 1110 Fairview Avenue prior to today?
I have.
Did you receive a variance in 2012 to operate a 6-unit apartment building at 1110 Fairview Avenue?
I did.
After you received the variance in 2012 for a 6-unit apartment building, did you commence renovations of the former Iris Club and create an apartment building?
We did, yes.
How many units did you create in 2012?
7.
Can you explain how you came to create 7 apartment units in 2012?
Yes. We came before this board before. We got approval. We applied for 6 to 7 units, and during construction, we pivoted and decided to turn the downstairs into the 7th unit during the construction process, due to a lot of decisions and requirements by the code enforcement officer.
Can you elaborate a little bit on the code issues and things that led you to?
Yeah, what we ran into is all the utilities had to come, basically plumbing, heating, had to be added to the base, what's labeled as basement on the plan, to meet the zoning requirements. So we had to provide mechanical ventilation, which we weren't initially expecting. We had to sprinkler the area. All the plumbing for the whole building comes down through that area. So during the construction phase, we decided to prepare the whole area to be another apartment.
Did you also, was there a requirement that you had to seal the walls?
Yes, we had to seal everything up, insulate it, so because it was heated, because there's water in the sprinkler system, so we did that. And that was so the pipes didn't freeze.
Do you believe that you had authorization of the borough's former building inspector with regard to the creation of the 7th unit?
I do.
And what leads you to believe that you had his authorization?
We had everything inspected throughout the whole construction phase in that area.
So this is not a case where you built another apartment after the 6th?
No, we have all the inspection reports, pictures from when it was done.
Are you now requesting a variance for the 7th unit and to reduce the size of parking spaces to comply with the amount of spaces required by the zoning ordinance for 7 units?
Yes, I am.
I'm showing you a drawing that's marked as Exhibit A2, which I also believe to be Exhibit A3 to the zoning hearing board application, which is the floor plan for the first floor in the basement of the property at 1110 Fairview Avenue. Do you recognize it?
I do.
Can you show and describe the zoning hearing board where the 7th unit is located?
So in the bottom left of the plan, you have an 800 square foot area and a depiction of a plumbing line on basement floor plan. That's the area it's in.
Mr. Mooney?
Yes.
May I interrupt you?
Yes.
I'm confused. Why are you here today if, for zoning relief that you already believe you have?
The decision, his application was for 6 to 7 units. The decision in 2012 was explicit that he granted 6 units. So he's got one additional unit over and above that, which was in the decision that was issued in 2012. Although his application was for 6 to 7, the decision was explicit for 6. During construction, there was a 7th one built, and it's been occupied continuously since 2014. So he needs a variance for it.
But you just said that you believe that you finished that unit within and it was inspected, and therefore you had the right to be there. And so why are you asking for a variance now when you believe you have the right to be there?
I'm giving you that testimony as background. There is no variance for a 7th unit. The Irish Club was formerly a men's club, to my knowledge and recollection.
I was there many times. Yes. Yeah.
My client renovated it into apartments. It was not zoned for apartments when my client renovated it, so he needed a variance to create the apartments. The variance decision that was rendered by the zoning hearing board at the time in 2012 gave him authorization for 6 units. During the construction phase, as my client is explaining, it became evident that he was going to have to create a much more livable space out of the basement in order to meet codes, which all were permitted. There's radiant heat in the floor, which he can go into.
I understand all of that, but it begs the question of why was this not done in 2000? Whenever
I think it was just overlooked. I think the building inspector at the time didn't say anything. He issued all the permits, and my client went about life. He went about life and eventually separated from the borough. And I think your new inspector was in the building this year and saw the 7th one, and here we are.
He didn't see it. I had him inspect. I was with, like, we weren't hiding anything. I took him to that unit specifically.
Okay. I'm still not.
I mean, I realize we're a decade down the road and this is odd, but.
Okay, all right. Sorry to interrupt you.
No, that's fine. Where's A4 and A8? I'm showing you photographs which were marked as exhibits A4 through A8.
Are you skipping over A3?
I'm skipping over A3 for now. We'll come back to A3.
Okay, so A4 to A8 are photographs?
Yep. Can you look at each one and individually describe what it shows?
A4 just shows the main living area. It's just it's a studio apartment. There's no bedrooms, so this is just the main living area. A5 is the called just the loft. You go up a few stairs and there's a smaller space. A6 is that same space. A7 just shows the bathroom, and A8 shows the inside of the bathroom.
Currently, how many persons reside in that 7th unit?
1.
Showing you a drawing that's marked as Exhibit A3. I believe that drawing to be Exhibit A7 to the zoning application.
Okay.
Do you recognize it?
Yes.
Can you point out the parking lot on the exhibit and describe its current condition?
So on the bottom, closest to where it says Terrace Ave, there's a diagram of the parking lot, and its current condition is exactly as it's drawn. There are no lines on it currently because we only have the one tenant has ever used it since we opened the building, so there's never more than one car.
parking lot was reduced in size, something for a building 2 or 3 years ago, 4 years ago, something like that?
No, we had a variance to replace the shed with a larger one. We never changed the parking.
May I interrupt for a moment?
Yes.
It was something that Mr. Rothenmüller said that is sticking with me. Are we to, when we're listening to you present your reason for a variance, are we to pretend that this studio apartment does not exist? And that, because when we granted the original variance, there were no apartments in it. And if we're looking now to grant, to extend the variance or grant a new variance, whatever it is, how do we do that when the apartment already exists without ignoring the fact that it does exist?
That is a tough question, and I've had that discussion with your former borough solicitor, Mr. Hartman, and I'm not sure how you address it, because had it been addressed at the initial zoning hearing, obviously it would have been a use variance. If you address it as a fresh request at this point, I believe it's a dimensional variance because the use already exists, and therefore our request would be for 2-dimensional variances, which would be to create additional apartment space because the use is already there, and then the dimensional relief for the parking lot in order to create smaller spaces than those that are required by the zoning ordinance. But
And Keith, in your answer to that, aren't you just now saying that it's kind of both ways? We either have to ignore the fact that it's there so he can put it in, or just say, it's there, what can we do?
again, I'm not saying it's not a quandary.
So Bob, I think at this point, what we have to do is, I understand your questions. We have to look at this because this was never approved. And the question, what kind of begs the question was the original decision specifically said 6 units. When the application said 6 or 7, the zoning hearing board specifically concluded 6. They built the 7th unit without the zoning hearing board's knowledge. We just found out about that now. So I think we're looking at this as if it's a fresh variance from the very beginning. I don't think there's any other way we can look at this.
Right, I understand all that. And my question is, then are we just to ignore that it's there?
No, those issues get taken up by the, I see what you're saying. Those issues of the violation would be taken up by Borough Council, and they would be done through an enforcement process, which I don't know, I believe probably, I see Michelle shaking her head, has already been undertaken with a notice of violation, and the borough will take that up. So if we don't, I assume, if we don't grant relief for the apartment, they will proceed with that notice of violation. If we grant that relief for the apartment, then that may not continue. But there's 2 pieces of here too, which raises another interesting issue, is there's also a request for parking relief. So we have to get into that piece of it as well, which is also a new variance request. So I think it's more about, I think your question, Bob, if I'm understanding it, goes more to the enforcement aspects, which is not part of the zoning hearings responsibility, that's Borough Council's responsibility.
No, actually, and I acknowledge I could be wrong on this, but when they're asking for a variance, but the apartment is already there, how do we go about and saying there is a need for a variance, except for enforcement purposes?
Because the original decision defined the relief as 6 units. They're asking for a 7th unit, so they're asking for further zoning relief. And
right, they're asking for something they already have.
No,
that's what I don't understand.
No, they're asking for a 7th unit. They never had authorization from from the zoning hearing board for the 7th unit.
I mean, I think I understand your question. We're asking for, or attempting to receive legitimization of what is there.
What was constructed.
Constructed.
With, in contrary to the relief that was granted by the zoning hearing board.
Correct.
All right, so do we really need to hear where it is and what was done when it's already there?
So that, I guess, gets to the zoning hearing board. If you're interested in understanding the hardship and what has happened, you then would want to maybe hear what they did, right? Even though it wasn't done in accordance with the ordinance because they added this unit, that's up to you in terms of what you want to hear about that. I think we're more interested in hearing what they believe the hardship to be that would establish the right for them to have the 7th unit.
I think the elephant in the room is that the hardship is if we say no, he's got to tear the thing
Right,
out.
that's right.
And that's clearly the hardship.
Right, well, that's actually not a legal hardship from the standpoint because it was done illegally.
No,
So it was not done with the proper permitting in place.
Yes.
So that's something that the borough deals with, not us. We just have to look to determine whether or not, forget about whether it's there or not at the moment. We have to look at determining whether or not there is, at this point, they have the necessary hardship to add that 7th unit. Even though it's there, was there ever a hardship that whether the zoning hearing board would grant that? The zoning hearing board made a previous
So what I
decision.
said was correct. We have to, well, what I'm asking is, do we have to ignore that it's there?
No, I don't know that you're ignoring, Bob, because ultimately what they're doing is they're explaining that there was some, what they believe, some misunderstanding, which I don't think you can just ignore it because it's happened. But the idea is that they're coming back in and saying, okay, maybe we didn't do it right, or we didn't get the proper approvals, we're coming in now, and by the way, here's what it is, and we would ask that you allow this to remain. That's essentially, as I understand it, Mr. Moon, is that correct?
That's essentially correct.
All right.
However, that's only one part of it.
Correct.
That remains is one issue. That you're in violation of the parking is the second and a wholly different issue. Correct.
Agreed.
Okay.
All right, Mr. Mooney, why don't you continue?
All right.
I'm showing you several photographs marked as Exhibit A9 through A7.
Mr. Mooney, sorry to interrupt you, but are we done with A3 here?
I believe so, yes.
So all you're telling us is that this depicts the zoning, or I'm sorry, the parking lot as it currently exists.
Correct.
And that's a total of 14 spaces?
Well, that's our proposed lining to make it 14 spaces.
Okay, so the parking lot then, this is not how it currently exists, because you're right, there's no lining
There's
on
no
it
line.
currently.
Yep.
And in order to put the 14, just so we're clear here, as I'm looking at this exhibit, so we don't have to come back to this later, hopefully, although we may, is you're asking for a reduction in the size of zoning, the zoning requirements for the size of the parking lots. So I believe the zoning ordinances require an 8 by 8.
9 by 18.
9 by 18. 9 by 18, is that correct?
That's right.
All right, so that's from Mr. Hogue for the record. And you're asking to come down to, and it's hard for me to read it, I need a microscope here.
7 by 6 to 8 by 18.
Okay, so you're looking to narrow the width by over a foot,
Yep.
right?
Yes.
And if you do that, then you can put 14. Is 14 the number of spaces that you would need for the requirements of the zoning ordinance?
Yes.
Well, and we'll get testimony. We actually will be one space over because there is a garage also on the property. But I have testimony with all that to come in the next 3 to 4 minutes.
Got it, keep going then, please.
I ask you to look at exhibits A9 through A17. Can you look at the photos and tell me if they are all photos of the building in question's parking lot?
Yes, they are.
Were those photos taken this December on various days and at various times during the day and night?
Yes, they were.
Do all of those photos show either an empty parking lot or one car in the parking lot?
They do.
Does the one car that appears in several of the photos appear to be the same car?
It is.
Do you recognize the car in the photos, and if so, who does it belong to?
Yes, it is the Unit 7 tenant's car.
And is that the state of the parking lot on most occasions, that either no cars or the Unit 7 car is parked in the parking lot?
Yes, that's correct.
Can you briefly explain why you believe that to be the case?
Yes, so we put the parking lot in to satisfy the requirement, a number of spaces, but due to the topography of the street we're on right now, Fairview, the lots are so steep and there's no access from this parking lot into the building. So units 1 through 6 all park on Fairview Avenue. And they're welcome to use this parking lot, but the only way to get from this parking lot up to the main entrance of the building is the very long burrow staircase that's not maintained in the winter, where you have to walk around the whole block, which is impractical. As the last 14 years have proved, no one's really ever used the parking.
Yeah, but you understand that the ordinance requires 2 parking spaces per apartment unit.
Yes,
Are you able to stripe the parking lot to create 14 spaces plus have an additional parking space in the on-site garage?
yes, we are.
In order to create the 14 spaces in the lot, would you need to reduce the size of the spaces from the required 9 foot by 18 feet to 7.6 feet by 18 feet?
Yes, that's what we do.
I ask you to take a look at Exhibit A18. Do you recognize that photograph?
I do.
Is that a photo of the building's parking lot and garage in their current condition?
It is.
Are you proposing to leave the parking lot in its current physical condition until such time that the borough would request that you stripe it in conformity with the proposal put forth today?
I am.
Do you believe that there are unique physical circumstances or conditions, including irregularity, narrowness, or shallowness of lot size or shape, or exceptional topographical or other physical conditions peculiar to this property, and that create a hardship?
Yes, I do.
Can you briefly go into those, although I believe you have touched on some of those?
Sure. So the geography of this whole area of the street is such that all the homes and buildings on it access their properties from Fairview Avenue, not down on the terrace, just because of how steep the lots are. So the hardship we have, and we always have had at this property, and so did the Iris Club, was there was never any way to enter or exit the building from the terrace. So the primary use of the whole property throughout its life, and all the other properties on the street, get in and out of their homes from Fairview Avenue. The existing homes, by and large, the vast majority of them also don't have any off-street parking in the entire. So, it's an issue on the street based on the topography and the way the neighborhood was constructed.
Have you had any complaints from neighbors or other surrounding residents regarding the parking on Fairview by your tenants?
No, we've never had any complaints from tenants parking on Fairview with street parking. We even have a tenant in Unit 4 that has a mandated handicap spot on Fairview that's reserved for them because they're disabled.
Do you believe because of these physical circumstances and conditions that there's no possibility that the property can be developed in strict conformity with the provisions of the zoning ordinance, and that the authorization of a variance is therefore necessary to enable the reasonable use of the property?
Yes, there is.
Have you created such unnecessary hardship?
No.
Do you believe that the variance, if authorized, will alter the essential character of the neighborhood or district in which the property is located?
No, I don't. Nothing would change.
Do you believe it would substantially or permanently impair the appropriate use or development of adjacent property?
Nope, it wouldn't change anything for adjacent properties.
Do you believe it would be detrimental to the public welfare?
Nope, it would not.
The variance if authorized, do you believe it would represent the minimum variance that will afford relief and will represent the least modification possible of the regulations at issue?
I do.
I have no further questions.
Just curious, how many of the units have only one occupant?
Yes. No, how
This
many?
unit has one occupant, but
Yes.
how many other units have only one occupant?
The rest of the units have 2 occupants, and they're much larger. Oh, I'm sorry, unit 2 is 1 occupant. Sorry.
I think, I think I expressed my confusion and my concerns, over this, to this point. Mr. Becker.
So I heard that no one else uses the parking. So are they all parking on Fairview?
Yes.
And I also heard you say just a moment ago, the tenants have complained. Have you had any complaints from the neighbors about parking?
Never. Actually, a lot of the neighbors have reached out, with praise for the whole project and how we've eliminated some issues with the property and parking.
What, in the original plan that you presented to the zoning hearing board back in 2012, I guess, what was the basement intended to be used for?
We had no plans for it originally.
Do you recall, was there any testimony about the basement at that time, if I'm back in my transcript?
I doubt there would be. It was one of these things where we're dealing with, roughly a 100-year-old building. We did the best we could to plan where utilities need to go, but at that point in time, in planning, we didn't know what the power company was gonna say, the gas company, we didn't know where we're gonna have to run, major utilities. So a lot of that was unknown, and one of the big ones was the sprinkler system. So, we knew what we knew coming in. That hearing was before we purchased the property. It was still owned by Charles Anderson when we had the hearing, so we really didn't have the opportunity to dive into the building, other than just a cosmetic level.
Yeah. I disagree with you. I remember the meeting, and even at my age, I remember some of the details, and I do remember there was a discussion about the basement, and the reason for the discussion about the basement was because it was the only place that could be accessed from the parking lot. And then the question became, the question at that time was, well, if we can go through, if the only way to get in is into the basement, do you have access to the rest of the building from the basement?
Yeah, so I thought you were asking the question about is it an apartment or not? There was.
Well,
yeah.
that is part of it, because you said, no, that's not going to be an apartment because because access to the rest of the building and all of those things.
Yeah.
That I remember.
Yeah, there was somebody that asked about putting an elevator in it at that hearing, and I think that's kind of where that conversation went. But we didn't know what we didn't know at that point in time, right? That building had a lot of skeletons and structural flaws when we dived into it.
I'm going to refer you back to Exhibit A3 that Mr. Moon provided. Does that doorway, there's a mat in front of it, is that the 7th apartment going through that doorway? A3, I'm looking at Exhibit A3.
No, he's looking at a picture.
It's marked A.
Oh, yeah.
Mark A3.
Yes, that's it.
So that's the door into the 7th apartment?
Yeah.
And is that the parking lot on Terrace?
Yes.
And I see that there's other vehicles there on that parking lot now for this picture, correct?
Yes.
there, would there be the ability to access by way of steps up to the first and or second floor?
No,
There never was any access that way?
no.
I don't believe I have any further questions at this time. So,
Dan, I do.
go ahead, Michelle, you have some questions?
Yeah, I have a couple of questions. Okay, Mike, first of all, I want to say you have done a fantastic job with the building. I was in it before when Mr. Anderson owned it. I've been in it since doing rental inspections, making a difference. I've never received any complaints after the relief was granted in 2012 about parking issues either from tenants or from neighbors. So, I mean, I can back your statement there that I'm not aware of any concerns. We did have prior conversations in advance of you submitting this application. You indicated as part of your testimony and applicant's exhibit, I believe it's A19, is a copy of an inspection report from Codemaster dated, Codemaster was the inspection company that performed building permit, plan approval, and inspections back in 2012, 2013 on behalf of the borough. I noted when reading the inspection report from the inspector, who I believe was Jeff Young, all of the units that were approved units per the building permit plans that I reviewed recently in advance of you submitting this application are listed as unit 1 through 6. Lower basement level, which is the area you're indicating Mr. Young gave you permission. You're stating he gave you permission?
No, he didn't give us permission for the unit. That wasn't his job. I'm just stating he inspected, as we did all the rental inspections. Like if we had an electrical inspection, he did the basement, what's called basement, all his inspection reports. So the reason we included that is just to show everyone that we were not hiding that unit. He, you know, when he saw we're doing radiant floor heating, the tubing, he said, hey Mike, I need to pressure test that. You know, when he saw we're putting in a plumbing for a bathroom, he inspected that accordingly. And, you know, he had to inspect the sprinkler system down there. We always had him inspecting down there. And then, other than the utilities that service just Unit 7, he obviously was down there because he had to inspect all the plumbing for the rest of the building, coming down and connecting into the street sewer and everything. So he was down there a lot. And we were just trying to point out that, you know, he did inspect all the things you can't see in that unit at the time of construction. And, you know, Jeff's a tough inspector,
Yes, he
if
is.
anyone knows him. You know,
Yes.
kind of the anecdotal thing is, our masons poured the steps 3/8 to 1/4 inch too tall on some of the risers, and he made us rip the staircase out and re-pour it, and then get a stamped and sealed engineer's diagram for the railing that is the entrance to Unit 7. So the reason we included that was just that, hey, you know, this didn't happen overnight yesterday. We did engage Jeff to make sure it was all inspected. I think the only thing that didn't get done is a finding.
So I just wanted to clear though for the record, and I shared what the borough has on record, which is the building permit plans you submitted to get an approved building permit to construct the 6 apartment units, only listed 6 apartment units. The certificate of occupancy that was issued for that building permit only listed 6 units. And every rental inspection, application, and permit the borough has issued since 2013 reference 6 units. There was never an application submitted for 7. A rental permit was never issued for 7 units. We only have record of 6 units, correct?
I believe so.
Okay. I just wanted to clarify that on the record.
So how often are the permits for that, for that?
Rentals? Rental
Rentals.
permits are issued every 2 years. So 2013, 15, 17, 19, 21, 23, 25.
So for all of those years, you had 7 units and only filed a permit for 6.
So if you passed, there was a point in time, we didn't have an inspection for a long time, because if you don't have a violation, it was a longer period at some
If
point.
you don't have a violation and your tenant does not change, but I shared with you and sent you,
Okay.
rental permits were issued for your
So-
property 13 through 23.
Sure.
Every 2 years.
So we never had any violations, so they were every 2 years, you're saying, right? I trust
But you were
Michelle.
entering a permit and flat out lying about what the permit was asking for.
We're just,
No.
Yeah.
You were filing a permit for 6 units and had 7.
yes, okay.
Thank you.
I don't have any further questions. Is there anybody else that has any questions for this particular?
I do not have any questions.
At this point, Mr. Mooney, do you have any further witnesses?
I do not. I would just point out that I believe the last testimony my client gave in response to Ms. Bear's question was borne out in Exhibit 820 with regard to the staircase that leads to the Unit 7 and the construction of the steps and the stamp drawing that my client talked about.
Mr. Does anywhere on this reference unit number 7 on the 820?
I think it's always talked about either as the basement or the lower section, which on this, it's talked about as the lower section.
But nowhere is it mentioning that's an apartment.
No, I think the
So
reason.
yes or no? I mean,
Yes, you're right. It doesn't mention
Okay.
apartment.
And you would need steps to get into the basement or lower area anyway,
And they
correct?
would have to meet.
And they would still have to be compliant, correct?
Exactly. So I guess the point is, if we're inspecting it, you know people are entering, there's giant 12-foot doors, there's a patio, a grill, you know, nothing was being hidden here from any inspections, you know.
When he was inspecting, did he ever acknowledge and say to you that he knows this is an apartment?
Yes, absolutely. Why we wouldn't put radiant floor heat in a basement for no reason.
Not necessarily. I mean, there could be lots of different
Yeah.
reasons why you would want that,
Yeah.
other than an apartment.
Yeah.
All right, I think that's all I have for this witness. Mr. Mooney, do you have any?
Just
further
one
questions?
follow-up on that. Exhibits A4 through A8, which are the interior shots of the unit. Is that how the unit looked upon its completion in 13, 14?
Yes, yes.
When it was being inspected?
Yes.
Did you ever get a permit for it at that time? As an apartment?
The assumption was we were doing active construction that was under our current building permit.
And there was never a final permit issue for it.
We never got a CO for it.
Do you want to do housekeeping?
No, so I want to just make sure, Mr. Mooney, do you have anything further?
I don't have anything
All
further.
right, so you rest?
Yes.
You're asking for the admission of all the documents?
Yes.
Okay, I don't have any objections to those documents.
No.
I do have the application now.
I thought you guys
I did, I just wanted to make sure.
Statements.
That's what I thought. Yeah, you better.
So at this point, the applicant is rested. I see that there are a number, and I noted from the record before, that there are a number of residents here for the hearing this afternoon that didn't ask for a stand, but asked for the opportunity potentially to make comments. So I'm going to go around the room, and I'm going to ask you if you have if you would like to make a statement, you have the right at this point to do so. Ask you to state your name, your address, and you'll be able to make that statement that we will, consider. I will also ask that you keep it to about 3 minutes. And also if somebody else who has already made the same statement, you don't have to repeat it over and over again. You can say, I agree with so-and-so, okay? So I'm gonna start over here on this side of the room. I believe that these two young folks are here observing with our code enforcement
That's
officer. So we'll start here.
I'm Barbara Brewster, and
So for the record, you state your address.
1110 Fairview Avenue, apartment 5.
Okay.
We have been,
Go ahead.
my husband and I have been residents of the apartment for 6.5 years. I can't go into the reality of the apartment. 7, it's been occupied, there's a few in here before that. I can attest to that there's only one car that is there 99% of the time in the parking lot. Because why would any of us who live on the Fairview Avenue entrance park down there and climb 71 steps up to our apartment? You know, on your list.
Keep the shape on.
That's the end of our war.
You do know it's yes. So I can attest to that.
So you have no objection to the relief that's being requested?
I have no further
So you concur with?
Oh, absolutely.
With this way,
Absolutely.
you kidding me?
Yeah, exactly. All right, go ahead.
Yeah, we'll get
All right.
together tonight.
Thank you very much. Appreciate it. Sir.
Vince Polak, I live at
I'm sorry.
1138.
Excuse me, say
Vince.
your name again?
Vince Polak,
Spell your,
1138.
will you spell your last name for us, please?
Polak,
And your address?
1138 Belmont Avenue. So my property backs on about 1123, if there was one, Fairview.
Okay, please proceed.
Okay, so you have the benefit of hindsight here, and in 2012, you required or thought it was necessary to have this man put 12 spaces in Matthew's apartment. You didn't intend to dump 12 cars onto Fairview for parking, but that's what happened. And when you have your UPS trucks, your FedEx trucks, your Amazon trucks come by and double park in the middle of Fairview, because there's parking on both sides of Fairview right in front of 1110. You can't get through. And when police are coming through on westbound call from this station, or when garbage trucks come through, they tie up traffic. So it's pretty congested. And I don't really see a good way to encourage people to park in the parking lot. It is 71 steps. That's really too much. Unlike in the open building, they built a roof and people want to be under the roof in the weather. So you thought it was required or necessary or appropriate to spend money on this parking lot that one car parks in. So don't have them spend any more money relining it for 14 cars. I was trying to think of positive encouragement or incentives for people to park in the parking lot, or negative ones. The only thing I could come up with was making no parking from the line of sight triangle signs that say don't park at the corner of Trent to the fire club. So that's 5 spots. And you already have the whole side, the south side of Fairview parked up with tenants. Which, by the way, park a couple of spots down from the property in front of the staircase and in front of the handicap access to the staircase, just because that's where they want to park. So other than eliminating those 5 spaces with a do not park sign, you dumped 12 and now 13. It's 2 for apartment and 1 for the basement. 13 cars onto Fairview. I just wanted to make sure that you consider that. I mean, in hindsight, you tried to avoid it in 2012, but now it's okay. That's what you're telling us residents.
Yeah, I don't know that we're telling you that. I think that we said, we gave the numbers, and we have to make a decision as to whether the next one is appropriate or not. That's what we do.
Okay.
Thank you very much, by the way. Mr. Jadick.
Hi, Adrian Jedic, 48 Cardinal Road. I want to speak about two things in support of this. I think, first of all, there is precedent. We were all here when you guys granted 1001 Reading Boulevard. Remember the skylight over the pool house? We were all here. And when that was built taller than it was supposed to be, there were plans submitted to Kraft that were approved, and then after the fact, it was found out that it was too tall, and I think close to the boulevard. So they came here, and there was no discussion. You know, they claimed that there was a hardship for them to take the skylight down. The pool house is still there right now, so it has a pointed skylight like this. There was $50,000 claimed that was the hardship to take it down and build it to the right amount. I think there was just a couple of feet difference. There was not much. So that went through. And I think here we have the similar situation. I think he has applied in good faith for 6-7 parking spaces. I've applied for parking for permits for zoning. He received the zoning. You say he lied flat out. No, when you apply for the permit, you apply for the permit based on your zoning application. I can't imagine how he didn't look. This zoning board gave us a wrong decision. And only because I'm OCD, I saw it, and I have a letter from Dan saying, okay, well, we understand, but this is it. Because at the time, Michelle said that the property line was at the curb, which is not. It's 8 feet behind the curb. So that created a cascade of errors, which our garage wouldn't have been able to be built. That's now I'm talking about my property. So I'm witness about this. So I think there is plenty precedent here. The other thing is, I also built during Technicon and during Codemaster. I know very well Jeff Young. He inspected my house. And I know what happened, and I know how that worked. And many mistakes happened. We also had the wall, or the situation with the wall. When the inspector came, he said, I don't have a permit. Michelle had given me a permit for the wall. It was a miscellaneous permit.
Focus on this.
I am focusing. I'm trying to explain that there is precedent.
Thank you. We understand your position.
So I think that mistakes happen. I don't see any ill will on his part. He was accused of lying. I think that could have been an oversight. I think he just thought it was going to be 6-7, probably acted on that. The inspector came, the inspector saw it, never said tear it down. And that was the situation for us. And I think never the inspector said tear the wall down because you don't have the proper permit. And that costed us $200,000 worth of lawsuit. Our inspector. So there is plenty precedent to understand a situation and say, okay, why do we have to drag this man now through this? We're all happy that building has been renovated. It's fine. What's wrong with it? That's all. Thank you.
My name's John Funk, F-U-N-K. I live at 1068 Terrace Avenue. I'm the closest resident to the downstairs apartment. And I'd just like to say, before Mike bought and renovated that building, it was, to watch my language, it was abandoned, run down, and pretty much a blight to the whole neighborhood. And now the quality of the tenants, and thank God for the installation of the security cameras, which have helped me out with police, with things happening in the area. The street in front of there is lit, which is cut down on all the lovers that park along there, because there are no houses there, and suspicious cars stopping up, somebody getting out, handing money out the window. I get to see all that. I get to see Happy Hollow. I'm right at Happy Hollow, so I know what's going on up there. I don't call all the time because I don't want to be that guy on the phone saying there's people up there and they're loud and it's midnight and the park's closed. But I just like to say that property's well maintained, and my neighbors and the visitors to Happy Hollow are all glad that Mike has taken it, and we appreciate what he's done to the whole neighborhood, improve the quality of the whole neighborhood.
Thank you very much.
Thank you, Mike.
Thank you, Mr. Schwab, appreciate it.
Just here to observe.
Just here to observe. Thank you very much. All right, so I think we now have asked everybody if they would like to make any statements. Mr. Mooney, do you have anything further in closing? I'm asking you to keep it brief.
I'll keep it real brief. I mean, obviously we believe that we have a hardship in the fact that the space had to be created and made into what was basically a livable space. And that was not my client's fault. It was a creation of building codes and other codes. He believed since the building inspector saw the livable space that was created, permits were given for the building, that he could rent the space. We had an inspection done this year by the current building inspector, zoning inspector, or I think that's what Mr. Hogue is. I'm not sure. One of those inspectors he is. And when we got the notice of violation, we promptly filed for the variance that we're seeking today. With regard to the parking lot, we provided the evidence that we provided to show that with a dimensional variance, we could create 14 spaces if needed, necessary. But our hope would be that if the variance is granted, that you allow the lot to stay as is, as an open lot with no lines, and that if the time comes when it needs to be striped, we would stripe it upon the borough's order. And we would be amenable to a condition that says within 30 days of receiving correspondence or an order from the borough to stripe it, we would stripe it. Thank you.
All right, at this point, I think we have some housekeeping to take care of.
Please, go ahead.
All right, so at this point, Mr. River, you are under oath.
Yes.
So we will ask you a couple questions. What's your capacity with the borough?
I am the residential zoning officer and code enforcement officer.
And in that capacity, did you have the opportunity to review and inspect this property?
My office did, one of our rental inspectors.
And as a result of that inspection, was a letter prepared regarding that particular property?
That's correct, a notice of violations you had mentioned earlier.
And do you have a copy of that letter that was prepared in connection with that?
I do not.
So the notice of violation you don't have. Was any other correspondence prepared related to this property?
A memo to the zoning hearing board.
All right, so you have that memorandum with you?
I did, yeah.
All right, we'll mark that as board exhibit number 1. Just hand that over to Mrs. Howard. In your capacity, do you have any other information that should be relevant to this consider?
I don't believe so.
Thank you very much, appreciate it. Now, let's switch gears here, go to Ms. Bear. Ms. Bear, what's your position with today's hearing in the zoning board?
I'm the secretary to the zoning hearing board.
And in that capacity, what are your duties and responsibilities?
I prepared a public notice that was advertised in the Reading Eagle on December 24th and 31st of 2025. That same notice was posted on the subject property on December 16th, 2020. Oh, sorry, wrong one. On December 18th, 2025 at approximately 11:30 a.m. and was mailed to all adjacent property owners located within at least 300 feet on December 16th of 2025 at approximately 9:30 a.m.
And do you have those documents with you this afternoon?
I do.
Mark those documents as board exhibit number 2. Do you have any other information for the zoning board?
I do. I would like to enter as Board Exhibit 2 an email between myself, Mr. Shervonic, and Mr. Mooney dated November 5th of 2025, 10:46 a.m., at which And Mr. Mooney, on behalf of his client, was granting the borough a 60-day time extension to hold the hearing outside of the 60-day time frame the municipality's planning code requires the hearing to be held in from when the application is received.
All right, mark that as exhibit number 3. Do you have anything further that you would like to?
The application.
Mark that as board exhibit number 4. And the zoning ordinance that was in place at the time.
Printed 2022, do you have it, Jeff? I think it's 2022.
I have 2018 here.
What we will do is we will mark the current zoning ordinance that was in effect at the date of this particular application as exhibit number, next to the board exhibit next to the
Four.
We're not going to move that into evidence, however, Mr. Mooney, we're just going to recognize that.
Understood and no objection.
Thank you very much. Those exhibits will all be moved into evidence. Ms. Baird, do you have anything further for the zoning hearing?
I do not.
At this point, Mr. Chairman, I believe we can stand in recess to do executive session.
Yes. We'll recess and see if we can come to a decision today, if you all will excuse us.
That's enough for a copy of my exhibits.
She has one, just because of.
Okay, we'll call this up. We'll call the meeting of Wyomissing zoning hearing board back to order. To deliver a decision, is there a motion?
Yes, I move that we deny the request for a variance by Iris Club Apartments LLC from section 609.2 off-street parking to allow 14 off-street spaces to be provided at the property measuring 7 feet, 7.2 inches by 18 feet instead of the 9 feet by 18 feet. And that we grant the motion of Iris Club Apartments LLC for variance from section 422, uses permitted by right to allow a 7th apartment unit to be occupied at the property, subject to the terms and conditions to be placed in the record by our solicitor.
Is there a second to that motion? Second.
Okay, and those conditions would be as follows. The first condition is that as it relates to the denial, let's first talk about that, is that the denial is relating to the size. There was not included in the application any request for relief as to the number. So to the extent you're looking for some relief to the number of spaces, you're going to be required to come back and file another application. That was not part of the application, nor was it properly advertised, so you'd have to come back and ask for that relief. As far as the relief, the unit, or let me also stop there for a second and go back to that, or you have to figure out how to get the additional unit spaces, one or the other. You can either get the number of spaces or come back and ask for further relief on the number of spaces. As it relates to the conditions for the approval, the conditions will be as follows, and that is that you must apply for and obtain permits, the following permits for that 7th apartment. You have to obtain a building permit, you have to go through all the steps that are required for that. You have to obtain a certificate of occupancy permit, you have to obtain a zoning permit, and you have to obtain a rental permit. Those applications all must be submitted within 30 days of the date of the written decision. You have to pay for all those application fees, whatever they may be as well, and they have to be properly approved before you can have occupancy to the unit. Or you have to move somebody out, let's put it that way, if it's not approved. And then also then we apply all of our standard conditions, and those conditions are essentially as follows. That you're bound by all testimony and exhibits that have been provided today at the hearing, that you comply with all the regulations of the zoning ordinance and any other applicable borough code ordinances. And as I mentioned, not only with those I mentioned a moment ago, but you comply with all other borough codes and ordinances, and to the extent there's something that I missed, we'd have to apply for permits for those as well. That you comply with all the federal and state laws as it relates to the use and occupancy of the property, that you will, you cannot otherwise alter or do anything different or inconsistent with this ordinance or this decision that will be written without coming back in for additional zoning relief, and failure to comply would cause immediate revocation of your zoning permit. Vote. All in favor?
Aye.
Aye. Motion is carried. The relief is partially granted. And that is all the business before the board today.
Thank you for your time. This was a tough one. I appreciate the time that you guys spent this evening.
Always good to see you, Keith.
Thank you.
Okay.
Thank you, guys.
Figure out.